We'll hear from Ms. Neely first.
This case is about Dorothy Frank, who is now deceased, being improperly denied eligibility for MassHealth long-term care benefits because she owned a life estate in real property titled in a nominee trust. The decision of the hearing officer with the MassHealth Board of Hearings, which was affirmed by the Superior Court, is wrong because it failed to apply the correct law with respect to the nature of real property interests owned by beneficiaries of nominee trusts. So too has MassHealth simply dismissed the relevance of nominee trust law to this case in its papers. However, the nature of the ownership interests of beneficiaries of a nominee trust is the dispositive issue to be decided by this court.
It's not a true trust at all. Okay, so if this is a nominee trust, then then it's not equivalent to a revocable trust. The words revocable trust have no meaning in this context. Is that true?
That is correct, Your Honor.
Any of the beneficiaries can revoke the trust. Then, if they revoke the trust, they get whatever they had under the trust. For your client, that's a life estate. But you've got the 5 children who have a remainder interest, right? MassHealth looks at this as a revocable trust. I understand your position as a nominee trust.
Correct.
The issue is, are there any circumstances under the trust in which the Medicaid beneficiary could be able to access the principal? But all she has under the trust is a life estate. For her to have anything beyond that life estate, there has to be another transaction, which is that the beneficiaries gift the remainder back to her.
She's retained full benefit of the property for her lifetime. And it seems like it's fairly significant that you not only get to transfer your house to your beneficiaries, but you get to keep the house too.
But within the 4 corners of the trust, all she owns is a life estate. So all you have access to, if at all, with your regulations, is the life estate.
I respectfully disagree, Your Honor. Under the language of, for 2 reasons. Firstly, under the language of the termination provision itself, any individual beneficiary may terminate the trust, even if this document is not in all ways a trust. What they did here should be looked at to see if it was an effort to shield the assets from being reached by Medicaid. But for purposes of counting assets for Medicaid eligibility, it is treated as a trust. And yet still, the assets must be counted if there is any circumstance in which the property can be given back to the grantor. And here, the language of the trust permits the property under some circumstances.
I mean, it's a trust at all. You keep saying that, assuming it's a trust. You keep assuming that this is a trust, and I'm telling you it is not a trust.
No, Your Honor. I'm assuming that it's a trust under the definition of the Medicaid statute. Under the Medicaid statute, any legal instrument or device that is similar to a trust, not even a trust. And here,
similar to a trust. Well, maybe it's similar to a trust. How is it similar to a trust? It's because it's called a trust.
Under the terms of the document, a trustee holds a property.
A trustee is an agent of Massachusetts law. It's not a trustee. It's not a true trustee either. Under Massachusetts law, it's not a true trustee either.
Your Honor, for certain purposes, that is correct.
What makes you think it's a trust?
Well, Your Honor, first of all, the definition under the federal statute determines whether it is considered to be a trust for accountability.
You're listening, it doesn't make any difference what our rules are in Massachusetts about nominee trusts?
This is not a trust issue per se under Massachusetts law. This is a Medicaid eligibility issue.
Well, it's your definition of what the issue is. I'm saying to you that I think it matters what the vehicle is in terms of what kind of interest she has under Massachusetts law. Under Massachusetts law, the nominee trust is not a true trust. Isn't that true?
No, Your Honor.
It's not true. Is that true? That is not true?
No, it is not true, Your Honor. A nominee trust is a trust-like vehicle, which
It is not. It is not. It's not what our law says. It is never what our law has said about nominee trusts. Nominee trusts are not true trusts. That has been clear for years.
It is treated as a trust only for the purpose of counting the assets for Medicaid. It may not be treated as a trust under Massachusetts law for purposes of liability, for purposes of transfer of ownership, for purposes of taxes, There are all kinds of circumstances under which it will not be treated as a trust. But for purposes of counting assets for Medicaid eligibility, it is treated as a trust. That is what the statute clearly says, and we have to go by the language of the statute. And in this case, we have to look to the federal statute to determine how it should be treated.
But counsel, the case law on the federal side says that federal judges or courts, like the bankruptcy court or whoever, are going to look at Massachusetts law to see what a nominee trust is. What's the definition of it? What does it mean? So we go back to our law again, even if you apply the statute, even if you apply the federal statutes.
Where there are efforts to shield property from Medicaid while giving the benefit to the families. That's what's happening here. And Medicaid has not counted that.
Thank you, Mr. Furgang. Do we have any further questions?
No.
All right. Thank you, counsel.